Due Process, winner of 19 regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights, and the 2011 Mid-Atlantic Emmy for Outstanding Discussion Series. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
Consider the extra weight carried by the court's unanimous 1954 opinion in Brown v. Board. All 9 justices signed one opinion, making it clear that the Constitution does not tolerate legally enforced segregation in our nation's public schools.
Brown was decided 40 years before she joined the court, but Ruth Bader Ginsburg has carried its tradition for nearly 2 decades. A voice for equal treatment and due process. So when the one-time Rutgers law professor returned to Newark for an international conference of women judges, we were there too. The iconic Justice Ginsburg, a due process exclusive, up next.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.
She's the oldest member of the court, just the 2nd woman ever to sit, and a justice whose distinctive voice we don't often get to hear. So when Ruth Bader Ginsburg came to town, we begged for the chance to record her speech. We're granted exclusive access, and Sandy and crew were there. I'm Raymond Brown.
And I'm Sandra King, and the event was an international gathering of the National Association of Women Judges in an unlikely venue, Newark, where Ruth Ginsburg taught law for 9 years. And that night, she had also come to teach. As a member of the minority in the court's 5-4 split, Justice Ginsburg's topic, appropriately, was the power of judicial dissent.
On rare occasions, a dissent will be so persuasive that it attracts the votes necessary to become the opinion of the court. That is a heady experience, and I had it just once. I wrote a dissent for myself and just one of my colleagues. In time, it became the opinion of the court, from which only 3 colleagues dissented. And whenever I write a dissent, I hope for a repeat of that experience.
When the court is divided and there's a powerful voice in dissent, that voice expresses the other view. That voice expresses with clarity our understanding that these are difficult issues and that you can think about them in a different way. And it may, as she said, point the way to the future, where we're going.
A classic example of an opinion appealing to the intelligence of a future day is Justice Benjamin Curtis's dissent in the court's most notorious opinion in Dred Scott v. Sanford. The court held 7-2 in Dred Scott that people of African descent whose ancestors were brought to the United States as slaves could never become citizens of this country, and African American could not invoke a federal court's diversity of citizenship jurisdiction in a free state to assert that he was no longer his master's property.
As we've seen in our history, as the justice laid out, the majority doesn't always do what's right, but as long as someone who was on the bench is working hard to set the record so that what is right will be recognized in the future, their work is not for naught.
Justice Curtis wrote, African Americans were citizens of at least 5 states, and so, in every sense, part of the people of the United States, and thus among those for whom and whose posterity the Constitution was ordained and established.
I think she came to tell us, don't be afraid. Don't be afraid to be in the dissent, because I think eventually that's the way that progress is made.
In Walmart, the issue on which the court divided 5-4 concerned the plaintiff's satisfaction of the threshold commonality requirement for class action certification. I observed in dissent that managers were overwhelmingly male, and they tended, perhaps unconsciously, to favor people who looked like themselves.
The justice touched on the Walmart case. If that's not an equality issue, I don't know what is. So we have come a long way, but we have a long way to go.
She went back to the basics. She went back to the basics of equality in women in pay, talking about the most recent Duke's Walmart case. And she also spoke about earlier cases that she was involved with.
In the rush to judgment in Bush v. Gore, for example, there was no time to compose a single dissent. So the press and public had to read 4 separate, rather long dissenting opinions to discern our views.
She seemed optimistic despite being on the minority side of the 5-4 juggernaut.
Yeah, precisely. And I think she's encouraging us to make progress and go forward.
While Justice Stevens in Citizens United, Justice Kagan in Arizona Free Enterprise Club, and Justice Breyer in the school assignment cases appealed to the intelligence of a future day, another kind of dissent aims to engage the public and propel prompt legislative change.
Justice Ginsburg, for all of us, stands as a trailblazer in a most remarkable way. I mean, she's a scholar. She has a presence about her. She's someone that most of us look up to.
To sum up, although I appreciate the value of unanimous opinions, I will continue to speak out in dissent when important matters are at stake. And I stress important because I do try to follow Brandeis's advice. Dissents need to be saved for major matters if the court is not to appear indecisive and quarrelsome. And he had his reward. His shots were all the harder because he chose his ground. In the years I'm privileged to serve on the U.S. Supreme Court, I pray that I will be granted similar wisdom in choosing my ground.
And despite 2 serious bouts with cancer and a shift in court balance, Justice Ginsburg shows no signs of stepping down. Now one of 3 women members on the court, she could have years more on the bench, a symbol of the heights women now can achieve after long years of exclusion in the law.
And no one was more aware of that change than the judges and lawyers who had come to hear her speech. The high point of 5 days of lecture and debate, discourse and exchange, and among the colleagues who were there to receive her, Judge Rosemary Gambardella, the first woman to sit on the United States Bankruptcy Court in New Jersey. Superior Court Judge Michelle Holler-Gregory, former Corporation Counsel for the City of Newark, and Francis Bouchou, Senior Associate Dean at Rutgers Law School and co-chair of this historic NAWJ conference. And Sandy, even though we've been warmly embraced at due process by Rutgers University, it's a coincidence that they're all distinguished Rutgers grads.
Without question. But let me start with Rutgers Dean Bouchou. As I sat and I listened to Justice Ginsburg's speech, I was so surprised that she didn't speak directly to the issue of women on the bench or before the bench or in society, but rather spoke about dissent. And Raymond and I have been wondering whether you think that was simply because it's on her mind as an important part of her role, or if there was some underlying unspoken message there.
Well, I don't know for sure. I didn't ask her. I don't have that insight. But I thought about that myself and thought that perhaps she was sending a message to the audience that There are times when opinions that come down are not going to be favorable to issues that are important to you. And the most recent one being the issue on the Walmart case. And I think she was sending a message that even when things look dire, even when the trend seems to be going against you, don't give up.
Yes, but why, Judge, when coming into a gathering, a historic gathering of women who've come to talk about women's issues, was she so oblique?
Well, first of all, it's important to note that not only American judges and lawyers and academics were in the audience, but we had a large cadre of international judges. And on the international scene, those judges are probably on the wrong side of many issues today. So it probably was even more inspirational to those judges to know that if you live long enough, your dissent may become a majority. And as well, I think Justice Ginsburg was speaking about her own life. Because if you look through her work as a law professor, as an advocate in so many famous cases, sex discrimination cases, ultimately she was able to write a majority opinion. Let's look at the Virginia Military Institute case.
But those weren't the ones that she spent her time
No,
on.
but it was reflective of the fact that that happened in her lifetime in those cases. And when I heard her speak about dissent, I thought about those other cases. I think she wanted to be relevant to cases perhaps of that were more recently decided. But I think she was giving a message of hope to those people that are in the minority.
Just let me ask a question that's somewhat counterintuitive, which is, given the long haul, is she going to be viewed as an important justice independent of her role as a pioneering woman in the field of law and justice?
Well, she's written important decisions on class actions, on procedural due process issues. She started her career, as I believe, in civil procedure. And her landmark cases go far beyond her work on behalf of minorities and women.
So
but of course, we're emphasizing some of those today.
So outside of her role as a pioneering woman judge, because I know we're going to talk about gender roles, but I thought it would be important to sort of establish an analysis outside the glass box.
She's an important judge and justice, period.
Now, an issue that came up, and Sandy and I are both competing to say, well, we were there and had a chance to participate in some small way in this important event. There was some discussion about the question of whether the slowly evolving larger numbers of women, I think we're maybe at 27%, on the bench, is symbolic and important just because women have a right to be wherever important decisions are made, or whether it makes a difference in the quality of justice for women to be judges. What's your view about the consensus of the conference or the discussion about that?
I think whenever a minority is in the room and at the table, it makes a difference. And certainly women judges have affected their male colleagues, perhaps not immediately, but in presenting a point of view that perhaps might have otherwise been overlooked. So if you're a single judge adjudicating a matter, obviously you work more in isolation. But on an appellate court, you certainly have the opportunity to influence your male and female colleagues, and I think that's where it's probably most pointed and most shown the need for women and minorities on the bench.
Judge Heller-Gregory, let me ask you about your own experience on the bench. You're now in criminal, but you worked civil for a long time and you worked family. There's this common wisdom that it's good to have a woman on the family court bench because they're more empathetic, because they can relate more. Firstly, is that true? Did that hold for you? And is the idea of having diversity on the bench important just because it's right and it's fair, or does it actually make a difference?
Well, I think that common wisdom may be out of step with the current times, because today we have male as well as women who are single parents raising children. So a male
but many
can
fewer
bring
numbers.
Fewer in numbers, yes, but a male can bring some of that perspective. I think men now today are more involved with their own individual family, so that wisdom that they bring to the bench as a judge, as a male judge, could be just as profound as a female judge. I do know that there are certain circumstances and issues that you do have to be aware of as a female that may affect the major caregiver and a relationship. But I think diversity on the bench is so extremely important. I have to agree with the sentiments of both my colleagues that diversity is critical because you bring a different perspective, and especially in the appellate division and for the Supreme Court, you need that flavor to understand the issues that are before the court. And with respect to Justice Ginsburg's speech and the issue of the dissent, I think that you saw throughout her speech that she made reference to future intelligence. And I think that was the message that she was sending out to all of us who were there listening to her, that there is a certain element of intelligence in the dissenting opinions that everyone should take and appreciate to move forward into the future.
Why did this have to be or happen to be an international conference? I mean, most of the issues that you talked about are critical issues and would be important domestically in terms of the United States. And there obviously is an International Women Judges Association. Why was it important for the National Association of Women Judges here in the United States to have this international context?
Well, I believe the presence of the international judges at the conference in Newark gave our conference tremendous energy. And the symposium that the dean organized, and I know she'll speak about, at Rutgers Law School was a tremendous day, speaking about the role of women internationally, issues of human trafficking. Ray, you were kind enough to moderate a panel on women's global issues that was the starting off point of the conference. And having those judges who are struggling through issues perhaps that we've already been through was inspiring to us because they had such sincerity, such energy, and they wanted to learn from us, and we really learned from them. And that is really what happened.
Let me give you just an example of what you're talking about, because the international flavor of the gathering was underscored by the international nature of so many of its participants, and we had the chance to talk to a few to ask who they were and why they had traveled so far. So we hear that there are women from 26 countries, judges from 26 countries here.
Yeah, I think maybe this is the first time the NAWJ conference has so many international judges.
My name is Jihan Batouti. I am Chief Judge in Primary Court in Egypt. We are 42 female judges in Egypt since 2007. Until now, we are in most branches of law.
What made it the most worthwhile was the topics that were under discussion, how they were discussed, and the fact that I can go home with a few, having heard of a few solutions and possible solutions.
The leadership of women judges. Yeah, I think that's quite important for a woman judge to lead her teams.
We have the same global issues to face, especially when it comes to women. So that is what I can, say was worth it about me coming all this way.
So it's valuable for you. Available for me? Everything I hear, I learned this, I can apply in my country.
Dean, let me share an anecdote with you and ask you to comment on it. An informant of mine said that after your human trafficking symposium, she was walking behind 3 judges who sit in the United States in family court who were saying that going to the human trafficking seminar had changed their perspective on judging in the context of domestic cases in America. What is that connection? How is that made?
Well, I'm glad you asked that question, Ray, because really the whole idea behind the global women's issues was the point that we are one global society, and the issues that we see internationally are here too. So what you're hearing from those judges, I actually spoke to some of those same judges, I think, because I was in that conversation. And what they said is that they learned things that they can bring back to their court.
Can you give us an example?
An example, one judge from New York, a family court judge, told me that she always asks questions about what the experience is of the litigant before her. But she said she hadn't thought about citing to international law in her opinions. And that was something, it just hadn't dawned on her until she heard those presentations. And she felt that she was going to do a better job as a judge, inspired by that presentation.
Judge Gambardella, on the question of dissent. We take for granted that dissents are made public, and it's not something that's hidden, and there doesn't have to be a unanimous decision on an appellate court or on the Supreme Court. And yet, for a lot of the women from those 26 countries, not so. They're not in that kind of system. And what kind of feedback did you get from them, especially, I wonder, after Justice Ginsburg's speech?
Well, I think in terms of Justice Ginsburg's speech, they were obviously just excited to be in her presence because she is such a charismatic person. But I think more importantly, the conference allowed them simply to speak. I mean, I remember instances during the symposium where several of the Egyptian judges just wanted to say something. So you're speaking about being unable to speak. And they were able at this symposium to get before a microphone, before some of the leading legal lights in the country and in the world, and say their piece. And I think they got great satisfaction just having had the ability to say so. Now, institutionally, is that available to them? You know, depending on the country, perhaps not. And it was frustrating. But the conference gave them the opportunity to go on the record. And I know that symposium is going to be published. So in those perhaps occasional public forums, these judges will have the opportunity, hopefully, to speak, even though institutionally they may be constricted in terms of their ability to do so.
I was in a session where that happened, where the Egyptian judges got up. But Judge Holler-Gregory, the other question is, this was in Newark. Now, I could imagine bringing judges from around the world to Miami or to Las Vegas, but to me it was intriguing, and it's especially intriguing given your long ties to the city, that happened in Newark. Was there resistance? Was that a conscious decision? Or was it just a coincidence that international judges from all over the world convened with American judges here in Newark?
I think initially there was some resistance, but I think the committee was so strong and we had a focus and a purpose that we knew that we could pull it together, that we had the Rutgers Law School.
But why were you strong? Why was it important?
Why was it
important?
You
said the committee was strong. Why was the committee strong?
Why was the committee strong? We had talented women there. We had women who were...
No, but to come to Newark, why was it important to take that position?
We were focused. The majority of us worked in Newark or had lived in Newark. I worked in Newark as the corporation counsel. The dean was adamant about it, and we had a vision that we wanted to say this could be done in Newark, the largest city in the state. We had a venue. We had something to offer the National Association of Women Judges as well as the international judges, something that was different, I think, than from past conferences. We had 2 universities that were joining us as a host in this, so we had an intellectual curiosity that we were able to present, and that forum helped with the international judges as well. And just to get back on the issue with respect to the international judges, and they wanted to have a voice in their concerns, to tie that into Justice Ginsburg's speech on dissent, I think it provided them with a perspective of how they might look at how they're forming their judicial systems, especially in Egypt, in Jordan, and Tunisia. We had those judges that were here, and they can look at the progress that we had in the United States, and possibly it'll be instructive with respect to their decisions and their struggle in formulating their judicial system.
This conversation has gone so quickly that we are almost out of time. So I'm going to ask you each to comment on the sort of bottom line question, I think, to all of this, which is, when is this going to be something that we no longer have to talk about? Whether it's the number of women judges or the quality of women's judging, when will this no longer be an issue? Dean?
We can't put a year on it. We can't put a time limit on it. I think that what we've learned through the evolution of, say, the last 40 years...
And I have to ask you to wrap in 5 seconds.
There is no time limit. I think we have to keep a close watch on the progress.
In 10?
And I think we have to continue to be vigilant, and I think that organizations, be they women's organizations, minority organizations, I think they have a role and a place in society, and I think that they'll remain strong.
And with
but
that,
our numbers are growing.
And with that, we are regretfully out of time. So with my thanks to our guests and of course to Justice Ginsburg. That's almost it for this edition of Due Process.
But before we sign off, we want to encourage you to join us next week and every week, to like us at facebook.com/DueProcessTV and watch episodes you might have missed on youtube.com/DueProcessTV. For Sandy and all of us here at Due Process, thanks for watching.
A classic example of an opinion appealing to the intelligence of a future day is Justice Benjamin Curtis's dissent in the court's most notorious decision, its 1857 opinion in Dred Scott v. Sanford. Justice Curtis disagreed in an opinion remarkable for its time. At the founding of our nation, he wrote, African Americans were citizens of at least 5 states, and so, in every sense, part of the people of the United States, and thus among those for whom and whose posterity the Constitution was ordained and established.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.